not restructuring. Restructuring doesn't involve further investment by the bank, further lending by the bank. First, the two options A and B above are seen not feasible. My unit is once found to be, not feasible. No, then recovery process may be resorted to. So the scheme entirely only this is a scheme which is intended to coexist with the order law. I'm not saying that it's a nature law, it's a special law, therefore it will override other laws. I'm not taking that convention because there is no need for me to do that. I say that the Surface Act will exist, the Current Action Bankruptcy Act will exist, IBC Code will exist, Negotiation Instruments Act will exist, the Recovery and Employees Code of EPF Act will exist, all acts, this coexist with the MSMED Act, coexist with the other enactments. But only thing says, look here, the banks, Provident Fund, ESI, all, look here, you can't recover without a MSME being afforded one opportunity for revival, and which is a duty. But the scheme is, and that is what RBI guidelines also say, you have to reach out to the small man. 80% of all MSMEs are micro. And earlier the
having outstanding of more than 50 crores.
Now there is even there is that now up to 250 it is permissible. 250. Therefore, that is not an issue. Now, what is there, they are under duty, but forget about even if this benefit has to be extended to even other companies also, because there is another notification of the Reserve Bank of India which says, and Supreme Court has said in Devinda's case and some other subsequent judgments also said, the notifications, circulation of the Reserve Bank of India are binding. That is the interpretation Supreme Court has given. I personally may not be agreeing with the Supreme Court interpretation, but when it is supportive of my client's interest, I certainly rely on the binding constitution of the Supreme Court in Devinda's case. It said the circulars, guidelines, etc., issued by the Reserve Bank of India under section 23 and 35A of the Reserve Bank of India Banking Regulation Act is binding. So therefore, therefore, even assuming for a moment that I am not even an MSME, I don't have to canvass that proposition. I am just telling it merely for argument's sake, and the benefit of many other industries who are facing recovery steps, that banks are under a duty to identify the stress even of a non-MSME also, and then before the default occurs, and then make an attempt for restructuring. But that is not a statutory scheme, only under the RBI guidelines. So therefore, thereafter, then the restructuring is not possible, feasible, then recovery is permitted. So all this, the intention of the Reserve Bank of India, as a statutory body which is tasked with the job of the control of the banking business in this country, they have in mind, RBI has in mind the interest of the banks and financial institutions, go to of the industry. So if the industry doesn't, the welfare of the industry, the interest of the industry is also in the larger interest of the economy of the country. So therefore, that is the scheme. Now, I don't have to go into all those issues. I only am confining myself to the rights which the MSMEs are entitled to. Therefore, this has not been done. My agony may not put it in the most humblest of humble ways, that I am so agonized to find, as a MSME, I am so agonized to find that this notification has not been given effect to by not a single bank or financial institution in this country.
Okay.
That is single, your lordship, as a court of equity, your lordship is exercising the power of the sovereign, the king, and for your lordship is the exercising the power. Even prior to the constitution came into existence, the king's bench in England. Therefore, a mandamus will lie. Your lordships are duty bound to put it all together, duty bound to call upon them. Why did you extend this benefit to the MSME? Why did you not give effect to the notification at all?
Okay, yes.
But therefore, now in my case, now your lordships always be, your lordship is known for your lordships, very balanced and a very kind and very practical approach. So, my lord, don't take it as I'm flattering your lordship. No, not it is. But the reality is the reality, my lord. Your lordship.
We are also known to dismiss the matters.
No, my lord. No, my lord.
Yes.
Therefore, the point is, my lord, the point is, my lord, they have not said. They have.
நீங்க ரொம்ப பிராக்டிகலான ஜட்ஜ் நான் பார்த்ததுல நல்லா இருக்கு ஜட்ஜ் யூ டேக் த தட்ஸ் a dismissal matter.
Please unmute yourself, sir.
Oh, sorry, my lord. I never knew that I was muted, my lord. Sometimes, yeah, my lord. Where did my lord? All the time saying that, my lord. Now, they have only said the accounts are maintained at Bombay. They have not stated anything in writing. They have not said anything put black and white. Therefore, my lord. Therefore, your lordship may direct them to maintain status quo. To maintain status quo, still they put something on an affidavit. Maybe that may not.
Hey, we are deciding the writ petition itself. Where is the question of maintaining? We may allow or we may dismiss the writ petition, either of the two.
No, my lord. Now the question is, my lord. Now.
Yes.
My lord, there is a. My lord, when your lordship says, whatever your lordship says, I accept with the folded hands. But my lord, subject to one word, my lord. Now.
An aggrieved party can challenge our order. Yes.
No, my lord. No, not that. No, my job.
Whether it is the petitioner or the bank, either of it.
No. My job is to convince your lordship. Argue my
Right,
case
certainly.
with the best of ability. And whatever comes to your lordship, I accept with all humility. Because, my lord, I have so much affection and respect for Justice Gangapula.
Okay, yes.
Therefore, the point
Okay,
is,
we have heard you.
No, my lord. The point I am conversing is that the battle lines have to be drawn, swords have to be crossed. The Reserve Bank has not entered appearance. The Reserve Bank has not said anything. I am making a very serious allegations, which is undeniable, that the Reserve Bank completely failed in its duty as a regulator. They failed to enforce the notification, and they issued further notification. So the Reserve Bank has not said anything. They are not even appearing, I suppose, my lord. And the Reserve Bank and the Union of India, Ministry of MSME, they are a necessary party. It is they have to be heard. My lord, now, my lord, I have in a small grievance, my lord, in the MSME matters, my lord, what is legitimate, and my lord, and it has been denied to a large extent at the hands of courts. It is, my lord, the courts always come to the court of mercy, court of charity, is akin to court of equity, which your lordships preside over. But unfortunate fact that not about your lordships, my lord, I am saying a grievance only, not no way of a complaint, my lord, not as a grievance only.
Yes.
The courts when it came to when it comes to the cause of the MSME, my lord, with a I used to say with a very, my lord, with a very great amount of agony. I should not be misunderstood, my lord. With agony only, my only expressing my agony. Courts have not come to our rescue.
Okay.
That has been our grievance, my lord. That has been our grievance. So that is something, my lord, when your lordships have to call upon them, answer them, why they did not extend the benefit.
Yes.
As the Reserve Bank of India, what are they doing? Not a single unit in this country has been allowed, given the extent of this benefit. And the Union of India, your lordships may issue notice to them. Let them appear, let them file a counter affidavit.
We are not inclined to stall any further proceedings, Mr. Nadumbara. Considering so many of the proceedings taken up by your client.
Pardon me, my lord.
Your writ petitions filed earlier against the orders directed to deposit the amounts are also dismissed.
No, my lord, no, my lord, your lordship, 1 second, my lord.
So, in view of that, we are not inclined to grant any interim protection to you.
I am answering 3 issues which your lordships have been pleased to put to me, my lord. One is, they are there in their counter affidavit. My lord, first principle, these are universal principles. Nobody can deny, there is no estoppel against law.
Yes.
There is no estoppel against law. My lord,
Okay.
Let me complete it, my lord. Let me complete it. See, somebody has said, I have moved the DRT, that petition is pending. My lord, there is concept is called allegiance contraria, known as Oriandibus. My lord, when it comes to facts, my lord, then if I have taken recourse to a forum or forum has taken a decision against me, or I have pleaded something in a particular fashion, then my lord, that will prevail. That will prevail. But question of law, the question, my lord, will prevail.
Okay, question of law will decide.
Question of law, there is no estoppel against question of law. And my lord, these are fundamental principles, my lord.
Okay.
I will quote a Latin maxim, my lord. In my lord, in Restitucata, my lord, Restitucata facit ex albo nigrum. A judicial decision on facts can make what was white black. Yes, nigro album. What was white black, and what was black white is negro album. Ex recto curve, what was straight curve, and ex curvo rectum, what was curved straight. So, my lord, a judicial decision on facts can make black and white, a man and a woman. Anything is possible. A court can make an innocent man find guilty of him murder, sentence him for death, and
Yes.
hang him. That is within your lordship's jurisdiction, and nobody can find fault with that. So, if not jurisdiction means obviously the jurisdiction to err, no doubt about it.
Yes, we have heard you on that, Mr.
But when it comes to question of law has no estoppel.
Yes.
This is a benefit which I am entitled to the law, which has not been provided
Okay.
to me. And the fact that in the DRT I did not read it will not act as an estoppel. A law can be pleaded any time. So therefore, the
Yes.
contention with the my lord, if at all, my lord, I believe that my lord, your lordship, and even I have got confused with the two cases. Now, my lord, the case first is Krishna Pring, right? Okay, fine. So sometimes when 2-3 matters are there, there's always one get confused with the other. Yes. In fact, I got confused with the Bombay matter and the the Tirupur matter. So that is, I'm sorry, I got confused with this too. So, my lord, my lord, the fact that an essay has been filed in the DRT, and the DRT, the protection of the MSME Act was not sought for, will not stand as a estoppel in my asserting my rights here.
Okay, yes.
Seeking declaration. Let me take your lordship to the prayers which I sought for in the petition. I'll take your lordship, because there is a saying, my lord, my lord, your lordship will forgive me, my lord, Roman lawyer says, Presidential Justitium Novelia Infortunate. My lord, hurry of justice with my lord, great misfortune. My lord, may I take your lordship to page 14, my lord? My prayer at page 14. My lord, at page 14, lordship, have a gracious look at page 14, my lord. Page 14. The lordship,
Yes.
my lord? Yes. Declare that petition is MSME within the meaning of the MSME Act of 2006, and notification dated 29/5/2015 issued by the central government under section 9 thereof. As also the circulars and guidelines issued by the Reserve Bank of India under section 10 thereof, which provides for a mechanism of resolution of stress, and that no proceedings for recovery under the Surface Act, RTB Act, or IBC will lie. Inasmuch as the MSME Act being a special law called the aforesaid Act, and the later law in relation to the Recovery and Bankruptcy Act and Surface Act, its provisions will prevail over the aforesaid enactments. My prayer was that this being a special law and the general and this later law, it will prevail over. But my lord, my lord, in my arguments, I am not insisting for that. I am modifying my contention that the legislations can coexist, and without prejudice to the other legislation, the benefit under the MSME can be extended, and if the resolution of stress is not possible, the recovery permissible. So to that question, my relief, I am modifying and limiting my prayer. But my lord, this prayer, my lord, in all humility, my lord, I am entitled to. My lord, I should not be mistaken for I am using the word entitled to. But my lord, entitled to the declaration to that effect. My lord, if your lordship doesn't grant the declaration, there is no other forum where I can go. And I go to the civil court, then my lord, the objection will come, then the bar under section 34 of the Surface Act, civil court has no jurisdiction, etc. Therefore, I have a difficulty. And therefore, this is the only court where I can seek this declaratory relief.
Yes.
Then, my lord, then prayer be declare that the MSME Act, insofar as it has not created a special forum or tribunal to enforce the interested rights and obligations / remedies, which it has created in addition to those rights and obligations and remedies recognized by common law. The jurisdiction of the civil court is not outside, for it is impossible to oust the jurisdiction of the civil court without providing for an alternative forum or tribunal to adjudicate the interstate dispute between the parties who are governed by the Act. My lord, I took your lordship last time, my lord, to the notification and the Act. This Act and the notification does not provide for any mechanism for enforcement of the notification and the benefit thereof. The only forum is a committee, the review, a provision for review which is before the very same committee. You know, that committee is a judicial committee and its decision may not final, may not subject to appeal if any. May not, no, the statute does not provide for any appeal. And therefore, it's a fundamental principle of law that when a forum like, unlike a court, a forum like the committee created under the MSMED Act, and the Act does not provide for any appellate forum or revisional forum, the jurisdiction of the civil court is not ousted. Supposing that somebody has to say that the civil court jurisdiction is ousted, then the consent of immediate semi-remedium that stand defeat. Access to courts and courts established by the sovereign, that is civil court, that cannot be denied until there is a forum which is in the form of a public law remedy is created. These tribunals, these committees created under the MSME Act is not is a public law remedy or public law forum. There is not even a court or committee was constituted. That is something like an internal mechanism, in-house mechanism, which has been conferred with certain limited judicial power for the purpose of the resolution of stress. But the committee contemplated under the Act is not a court or tribunal in a strict sense. So therefore, the jurisdiction of the civil court is not ousted. So now for this, the benefit of the scheme has been denied to not only to meet the thousands of MSMEs in the width and breadth of this country. Therefore, I in all humility insist that I'm entitled to, I'm using the word consciously, but in all humility, that I'm entitled to a declaration at your lordship's hands that the civil court jurisdiction is not ousted. If the civil court jurisdiction is not ousted, then I don't have to come here. I don't have to trouble your lordships. Now, when it comes to the question of your lordship in the earlier judgment in another matter, your lordship has been gracious enough to relegate me to the DRT. Now, the issue, what is the difference between a court and a tribunal is, the tribunal, it is always, a court, unlike a tribunal, it is pursued, is a quarter record of plenary jurisdiction, empowered and competent.
Yes.
And I would say, upon a civil stage under the sun. So the humble civil court has all the powers.
Okay, yes. You have argued that.
Especially part. Here, therefore, the tribunal, your lordship delegated me to the DRT. DRT under section 17 of the DRT Act, under the Surface Act, can only go into the correctness or otherwise of the measures taken under the section 13 of the Surface Act. And now my rights emanate from the notification, and the notification is not surfaces anything. It protects me even against recovery under the Income Tax Act also, or ESI, BF, and the border fund, and even lease rent. So also a complete protection. So therefore DRT, a petition under section 17 of the DRT cannot grant any declaration. DRT has no jurisdiction. If your lordships were to hold that the DRT has a jurisdiction, then your lordship would be conferring the DRT a jurisdiction of a civil court, which in all humility is.
Okay, yes. That's all.
No, but one more prayer, I don't read all prayers.
Your brief argument was more than half an hour.
No, my lord, now, prayer C, my lord. Declare that section 5 and 6 of the Surface Act of 2002 is unconstitutional and void inasmuch as it permits alienation of properties of a secured debtor stand borrower without notice to him, lay entirely behind his back, thus impinging Article 14 and 19 of the Constitution of India. Now, my lord, the larger issue, my lord, therefore, this issue, nowhere, there is no decision on this point. Whether, my lord, the assignment under Section 5 and 6 can be given effective without any notice to be served on the, or without the hearing the borrower. And, my lord, it is a fundamental principle of any where a public law remedy, any public law function, nobody can exercise a function without there being, with observing the principles of natural justice. Now, let me take your lordship to prayer D, to declare that the entire proceedings at the hands of the respondent 3, 4, 5 and 6, authorized officer of the State Bank of India, judicial magistrate, Tirupur, NCLT, Chennai, under section etc. of the under section 7 of the IBC are illegal and void, and a consequential writ in the nature of certiorari or any other appropriate writ order for quashing and setting aside the same. Now the question, the last occasion, your lordship was pleased to point out to me that the NCLT has admitted an application by the bank invoking section 7. RP has been constituted, and therefore that the ensuing management has been removed, and so this petition will not be maintainable. But here the petition is not filed by the company. It is filed by the managing director, on the borrower, the guarantor in his personal capacity. Now the question is the fundamental flaw with the IBC Code, SARFAESI Act, and Recovery Debts and Bankruptcy Act. Under any of these forums, under any of these enactments, I cannot go to DRT or IBC Code on the premise that there is the banks and financial institutions have committed injustice. I can only go there as a defaulter. But not only under IBC Code, only 3 sections where under I can go. But not section 7, section 9 and section 10 as a defaulter. Give me IBC Code. Yes, section 7 by the Bank of Financial Institution, section 9 by the operational creditor, and section 10. Section 10 can be invoked by a secured debtor or a borrower. Forget about secured debtor, a borrower, only as a defaulter. Therefore, my lord, now my case is that I am entitled to the benefit of the notification. The bank is at default. I am entitled to compensation and damages. I am entitled to set off counterclaim and all. And therefore, my lord, if our legal system, my lord, in our legal system, certainly the rights and obligations where it is mutual, the law will provide for an opportunity for both parties to agitate and succeed, or agitate and fail. So here, in these enactments, and the bank can invoke section 19 of under the Recovery Debts and Bankruptcy Act. The bank is an actor. I cannot go there. I cannot be an actor. I am only a RES respondent. Under section 13 also, I cannot invoke section 13. Section 13 can only be invoked by the banker. So therefore, actor, judice RES, I am a respondent and I defend the opposite party. And then under the NCLT or IBC Code also, only the bank, operational creditor alone can go as a person aggrieved by the injury at the hands of me. I cannot go in any of these forums complaining that I am a victim, I am a person aggrieved. So therefore, these aspects have not been considered in any of the judgments. All judgments proceed on the single premise that the borrower is always at fault. All rights and remedies operate against the borrower, and nothing can be claimed against by the borrower as against the banks and financial institutions. So IBC Code is completely defective, and when a legislation is defective, your lordships have the power to hold it unconstitutional.
Yes, that's all. Mr. Counsel, we have heard you enough now. For more than half an hour, we are hearing you.
Now I will only take your lordship to 1 minute more. I read the prayer only. I won't take the rest of the prayers. I will not read even. I will only take your lordship to. Your lordship be kind to me. Lordship has always been kind to me. Your lordship be kind to the Department, my lord. Your lordship may take your lordship to prayer E. Prayer E, my lord, because what I am ventilating is the tribulations of the cries of the thousands and thousands of MSMEs who have been denied justice. Now, my lord, that is my lord. Rich people are always saying, my lord, I represent the most weakest of the weakest, the most.
Your definition of poor is then very large.
My lord, who are 80% of the MSMEs are all, my lord, are only single units, micro. What is there? They only the owner, the borrower himself. He himself is running. His wife is involved. His son is involved. Or one worker is involved. That is also MSMEs are not rich. That's a my lord. It's a myth to say that they are my lord. They are financial. They are in distress.
Yes.
And they are in distress because my lord. If I tell the reasons why they are in distress, because that would.
Yes, you did your prayers now.
Yeah, prayer, my lord, prayer.
Yes.
To issue a written in nature of certiorari or any appropriate written order direction calling for the entire records and proceedings at the hands of the organization of the as well as the judicial magistrate to report, leading to the order dated 21/20/23 in criminal MB, etc., and to quash and set aside the same as without jurisdiction. Now, my lord, here it says, here look at the agony, my lord. A magistrate, upon an application received by the bank under section 14 of the Surface Act, without notice to me, if pass an order against me directing my properties to be taken possession of. Now, my lord, this would anyway, anytime, in any system of my lord, law, where the concept of rule of law prevails, can it ever be done? My lord, this is, and if I am an MSME, my lord, how come the invocation of the Surface Act comes? And my lord, then there are some statements which say that this, Madras High Court also I have come across, which says that it is a ministerial function. That it is certainly not, it's not a ministerial function. I take your lordship, section 14, I take your lordship a little more time, my lord, with a little more time. I may be pardoned for taking time, my lord, but because this is an issue which is affecting the lives and, my lord, livelihood of poor people, thousands of poor people, thousands of workers also, my lord. I take your lordship, my lord. Your lordship will certainly have the Surface Act, my lord. May I take your lordship to section 14? Very briefly, my lord, very briefly. I will not read the entire section. I will read a little bit of section 14. May I have your lord? Can I have your lordship have the book, my lord? Surface Act?
Yes, read further.
Yes, section 14. Section 14,
yes.
My lord. Yes. And there's a proviso has been inserted by Act 1 of 2013, my lord. Act 1 of 2013. Yes. May I take your lordship that?
Yes.
Provided that, my lord, any application by the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer of the secured creditor declaring that the agreed amount of the financial assistance granted and the total claim of the bank as on the date of filing the application. The borrower, then my lord, borrower has created a security interest over various properties and the bank or financial institution is holding a valid and subsisting security interest over such property and the claim of the bank or financial institution is within the limitation period. The borrower, then my lord, the borrower has created security interest over various properties giving the details of the properties referred to in clause above. My lord, the borrower has committed default in repayment of the financial assistance granted aggregating the specified amount. My lord, consequent upon such a default in repayment of the financial assistance on account of the borrower has been classified as a non-performing asset. My lord, affirming that the period of 60 days notice as required by the provisions of subsection 2 of section 13 demanding payment of the defaulted financial assistance has been served on the borrower. My lord, the objection or representation in reply to the notice received from the borrower has been considered by the secured creditor for reasons for non-acceptance, etc. Then, my lord, 8. The borrower has not made any repayment of the financial assistance in spite of the above notice of the above notice of the authorized officer. He is therefore entitled to take possession of the secured asset. So here, but in this case, therefore, the 9 items, including the fact that, my lord, whether any payment has been made subsequent to the issuance of notice under section 13.2. In this case, my lord, subsequent to the issuance of the 13.2 notice, further the payments have been made. And, my lord, therefore, the magistrate is called upon to, my lord, ascertain certain facts. Well, the notice under section 13.2 has been served. whether the any payment has been made subsequent to the issuance of the 13th notice. So in my case, further payment has been made. So now, therefore, these nine points which the legislature has incorporated by amending the law is it requires an inquiry on certain limited facts, and therefore, if such an inquiry could it ever be conducted without behind the back of the borrower, the person affected whose property is ought to be taken possession of. Therefore, the function here is a judicial function. And my lord, if it is even in PAMs also, your lordship, sometimes the law says that it is a non-adjudicatory function. If it is non-adjudicatory, then courts have no business. Court's function is not to do anything which is, non-adjudicatory. Court exists to adjudicate disputes, nothing else. And therefore, there may be a limited, the inquiry to be conducted may be limited in nature, but it's involved certainly the ascertainment of certain facts. And in my lord, a list, my lord, if the definition which the Supreme Court has given, my lord, a list involves assertion of certain rights and denial of the same, or obligation by one and denial of the same by the other. And my lord, then asserted they need to find out the truth thereof by allowing both parties to such a dispute to adduce evidence and giving both parties an opportunity to contradict the evidence appearing against them. And my lord, affording both parties to give an opportunity to, my lord, appreciation of evidence, and finally, my lord, on the questions of law involved. Therefore, my lord, the function here is certainly a judicial function. And therefore, any judgment to the contrary of this court, my lord, and there are judgments, being online, I am unable to hand it over the copies of the copies, are all rendered per incuriam. Your lordships are bound only by judgments which are in consonance with the settled principles of law. My lord, the first principle of jurisprudence, odi alteram partem, my lord, Seneca in his thesis, Media said, we started in parte inodita alteram, ecum desit statuti, what had come possibly. Odi alteram partem has come from there. He who decides anything without the other party being heard, though does right, does wrong. So, my lord, the magistrate, in passing an order without notice to me and without hearing me and without affording me an opportunity to conduct that I am an MSME entitled to protection of the notification, etc., has acted in gross violation of the principles of natural justice. And this issue need to be re-agitated. The issue need to be reconsidered, not reconsidered, because the judgments on this issue, which are there are many. There are many of not only of the Madras High Court, other high courts also, are all rendered per incuriam. It is against the first principles of natural justice. No court has the power, allowed in a system governed by rule of law, to decide anything behind the back of the party affected. If there is such an urgency, we cannot wait for then, the post-decisional hearing. Before the decision, no hearing is not possible. But immediately after decision, a hearing has to be extended.
Yes.
So therefore, these matters are required, proper consideration. And my lord, the stakeholders involved are, my lord, the Union of India, the Reserve Bank, my lord, the bank's financial institution. Therefore, my lord, the matter requires to be admitted. And my lord, the battle lines have to be drawn. All these issues, whether the function is administrative, even if it is administrative, my lord, the Supreme Court in Kraipak and in Menon Gandhi and any number of decisions have said the distinction between administrative and judicial function has come to an existence. Now there is no such hard demarcation, my lord. Therefore, my lord, what was said in the Police Commissioner's case, the Calcutta Police Commissioner's case, where all inquiry, my lord, was whether the function is judicial or administrative. Or it is administrative, no, there is no obligation to afford a hearing. That has all gone, my lord, with the landmark judgment of the House of Lords in Ridge versus Bambin, which has been followed by Katina judgments of the Supreme Court, my lord, with the Veena Devi's case, my lord, with the Kraipak, with the Menon Gandhi, with the Spacey Potterman, my lord, and my lord, later, my lord, in D. Gowlow's case, 19th Constitutional.
Yes.
Therefore, my lord, my submission, my lord, I am entitled to be protected, and the NCLT has acted in the order of the NCLT is without jurisdiction, and it is a nullity, and my lord, therefore, the petition may be admitted. I am only begging for that, my lord, your lordship may admit my petition. Let notice go. Let counter affidavit be filed.
Okay, that's all.
That's all, my lord.
We are not inclined to grant you any protection. Heard the learned counsel for the petitioner at length. The petitioner in the present writ petition seeks multifarious reliefs, such as to declare that the petitioner is an MSME and the notification dated 29/5/2015 issued by the central government under Section 9 and the circulars and the guidelines issued by the Reserve Bank of India under Section 10, which provides for a mechanism of resolution of stress, and further no proceedings for recovery under SURFACE Act, RDPI or RBC will lie. It further seeks directions to declare Section 5 and 6 of the SURFACE Act of 2002 as unconstitutional and void. So also seeks declaration with regard to the proceedings under the SURFACE and the IBC as illegal and void. The petition also challenges order under Section 14 of the SURFACE passed by the CJM Tirupur. It also seeks relief to prohibit and restrain the respondent bank from initiating or continuing any measures under the SURFACE para. The foremost submission of the counsel for the petitioner is that the notification issued by the Reserve Bank of India, the notification issued dated 29th May 2015 under Section 9 of the MSME Act 2006 by the central government is mandatory and binding upon the banks. It is mandatory for the banks to constitute the committee to identify the incipient stress. The subcategories are created as SMA-O, SMA-1, SMA-2. It is further submitted that the respondent bank has miserably failed to adhere to the notification. In fact, none of the banks are adhering to the said notification. The Reserve Bank of India and the central government are bound to reply. It is further submitted that taking up the proceedings before the DRT would not operate as an estoppel. There cannot be an estoppel against the statute. It is further submitted by the learned advocate for the petitioner that the petitioner has filed the present petition not on behalf of the company but as a guarantor in the personal capacity. It is submitted that protection needs to be granted against the bank. The bank has filed an affidavit. As far as the challenge to the provisions are concerned, we may issue notice to the respondents. However, we are not inclined to pass any interim order in favor of the petitioner for following reasons. Number one, the company is already gone into CIRP under the orders passed by the NCLT 1 Chennai dated 25/9/2023. The company can only be represented by the resolution professional. Number two, there is nothing on record to suggest that the petitioner is a running concern and is at present engaged in manufacturing and or any activity. Para. The petitioner has taken up multifarious proceedings wherein time to time conditional orders were passed, the petitioner failed to comply with the conditional orders. The petitioner filed securitization applications bearing number what is the number of the first one? Had filed securitization applications bearing number 992 of 2022, that is DRAT. The directions were given in the said securitization application by the DRT to deposit an amount rupees 14 crore 69 lakhs 22,934 on or before 3/1/2023. The petitioner challenged the same by filing writ petition. The petitioner challenged the same by filing appeal before the DRAT. Subsequently, the petitioner filed a writ petition bearing number 35065 of 22 challenging the order passed in waiver application. This court under order dated 2/1/23 directed petitioner to comply with the conditional order within 2 weeks. From 2/1/23, the petitioner failed to comply with the conditional order and the appeal filed by the petitioner was dismissed. The petitioner challenged an order passed under section 14 of the SARFAESI by filing SA number 105 of 2023 before DRT Coimbatore. The bank has sold 3 properties of the petitioner under various sales. The petitioner has again filed SA number 21 of 2024. The DRT passed a conditional order on 22/1/24 staying the sale confirmation subject to payment of an amount of rupees 27 crores in 2 installments. Whereas rupees 13.5 crores payable on or before 20th of February 2024 and another 13.5 crores on or before 20th of March 2024, The DRT further ordered that failure to make the payment of the first installment would render the stay order automatically vacated. The petitioner has failed to comply with the order and the amount rupees 25 crores as directed has not been paid. The petitioner challenged the same by filing a writ petition. The writ petition is the petitioner earlier has filed writ petition 17409 of 2023 challenging the order passed by the CJM Tirupur under section 14 of the SARFAESI. The petitioner gave an undertaking before this court on 6/7/23 that he will deposit a sum of rupees 25 crores within the period of 7 weeks. Pursuant to the said undertaking, this court granted interim order for a period of 7 weeks. After enjoying the interim order, the petitioner did not make the payment of rupees 25 crores to the bank. Eventually, the said writ petition was dismissed on 25/8/2023. The writ petition 31756 and 31832 of 2022 were also filed by the petitioner, forbidding the bank from confirming the sale pursuant to the issuance of the sale notice. The said writ petition was disposed of on 28/11/22, directing the DRAT to dispose of the waiver application within 2 weeks. It needs to be considered that the petitioner has not complied any of the conditions that were imposed by the DRT/DRAT or even failed to comply the undertaking before this court in the earlier proceedings. As contended by the bank, an amount rupees 58 crore 76 lakhs 91,734.91 is outstanding against the company and its guarantors. Now the company has corporate under IBC, the corporate insolvency resolution process is underway and order has been passed for 25/9/23. The company as such is not operative. No purpose would be served. The auction sale has already been concluded. The petitioner failed to comply with the interim directions issued from time to time. In view of the above, the petitioner by its conduct has failed to seek interim protection from the court. In light of the above, the request for interim protection is rejected.
I will submit myself to whatever documents have dictated, but one way, my lord. My denial may be recorded, my lord. The unit is functioning.
Yes?
Your lordship may.
Okay, Mr. Nadapara, the learned advocate for the petitioner, submits that the unit is functioning.
The unit,
Okay.
unit is
It is under IPSC resolution professional is appointed. What is this?
My lord, unit was functioning till it was taken out.
See, unit was not, resolution professional is already appointed.
No, my lord, till that day, it was functioning.
With
It was
regard to
it was a
the
working
issue
unit,
notice
it
to
was taken out.
respondent.
Working
Okay,
unit was okay.
yes.
Then, my lord, the second matter, my lord, here, now, my lord, let me confine my relief to a narrow, my lord. I made a request for a constitution of a committee. In this,
Oh, 1 minute, that is 69. We have another matter in between.
No, my lord, 69.
Yours is 69 now.
Yeah, it's Krishna Ping Minerals, my lord. Krishna Ping Minerals.
Okay. Yes, 69.
Yes, my lord. Now, I made a representation.
Yes.
And then, my lord, the bank has to state what action they have taken. I did not receive any reply.
Yes.
Issued a demand notice after which we made a representation. The unit is not functioning from March 2022 and he is not complied with the sanction terms and conditions requiring him to create a security of a property in Bombay. That he is not done. Further, my lord, the limit has been granted in Prabhadevi branch of Bombay and the unit is at Vizag. That was the objection also I took, my lord. I'll file a counter, my lord, putting all this matter.
File a counter.
Let my friend file a counter affidavit. Yeah? Let my
Okay.
friend file a counter affidavit.
The learned counsel for the bank, 6 time to file counter. 6th of June. Yes, next matter. 71.
71, my lord, some kind of a discussion is going on between
68,
the
this
bank.
was 70.
Yes. Yeah, my lord, some kind of a discussion for settlement.
Item number 70, Ramalingam and Associates.
Yes. Yes.